Hi, welcome back. Continuing with our discussion of contracts, we now talk about performance. Performance of a contract. Now, the parties to a contract have to be able to determine when the contract's obligations and their rights have terminated. And the termination of a party's obligations under a contract is called discharge. Now, discharge can occur in different ways, and that's what we're going to be taking up in today's topic. Generally, the parties can either perform as according to the contract, or the parties can be released from performance through a number of means that we will discuss later. So today we're going to look at performance and discharge of a contract. Let's start with performance, discharging obligations through performance. Now, parties to a contract must perform. That's what you've agreed to in the contract itself. And generally, the parties agree on the contractual terms, and generally, parties perform their obligations in good faith to complete the contract. This is how most contracts in the world work. Performance occurs when the parties do what they promised. Now, both parties discharge their obligation to the other by performing their agreed upon duties. So if you and I have a contract in which I am going to mow your yard in return for $50, my obligation is to mow your yard. Your obligation is to pay me $50. And when that has been accomplished, then the contract is terminated. Our obligations have been fully discharged. Now, there is a way when parties can adjust a particular risk associated with performing a contract by attaching a condition. And this condition can change the performance obligations. Now, there are three categories of conditions, and these are pretty well explained in your textbook. One is condition precedent. The second is condition subsequent. And third, condition concurrent. Now, when these conditions are present in a contract, courts tend to enforce strict compliance standards, meaning the conditions must be met in order to enforce the contract. Starting with condition precedent. And what this says is there must be an event occur before performance under a contract is due. So, for instance, an employer hires a student for a job to begin after the student graduates. And many of you are in that position now. You are being hired for a job even though you've not yet graduated from college. Nevertheless, graduating from college is a condition precedent. And if for some reason the student fails to graduate, then the employer's duty to perform, which is to say hire the student, is discharged. The condition precedent was not met, and therefore the employer was under no obligation to fulfill its performance under the contract. Now, the second type of condition is called a condition subsequent. And a condition subsequent specifies an event that will discharge the party's contractual obligations if it occurs after performance under the contract. For example, an employment contract, which would require that a party obtain a professional license within a certain time period after being hired. These are actually quite common in the law, for instance. When you are hired by a law firm, generally your bar results are not yet present at the time of your hire. So you graduate from law school, you take the bar exam, you get hired, and then several months later you will receive the results from your bar exam. The bar exam is held in July, but in a state like Texas, the results of the exam are not available until early November. Law firm hires you with a condition subsequent that you will pass the bar exam. Now, they're going to pay you, they're going to discharge they're going to perform according to their terms, but if you have not passed the bar exam, in November. Sometimes firms will give you a year in which to pass the bar exam, but in any event, then the firm has discharged its obligation. And I understand the same thing may be true for accounting firms, but you'll have to look that up for yourself. Finally, condition concurrent. This means that the parties have agreed to perform simultaneously. So, for instance, you buy a good. Well, when you pay upon delivery of the good, then you are fulfilling a condition concurrent. You rarely see these in the law. You will see condition precedent and condition subsequent pretty often. Discharging obligations through good faith performance. Now, if the promises to perform in a contract are not conditional, then the duty to perform is absolute. And generally, good faith performance of agreed upon duties discharges the contracting party's obligations. Now, there is another way of discharging your obligation, and that is through what's called an assignment. The parties can agree to an assignment. And an assignment occurs when one of the contracting parties transfers their rights under the contract to another party. So assignment occurs when one of the contracting parties, the one who has duties and obligations under the contract, transfers their duties and their obligations, as well as their rights, to another party. The first party is called the assignor. The second party is the assignee. The assignment discharges the assignor's contract performance, meaning now I have given my rights and my obligations, I have transferred those to a third party. And so the original party with duties under the contract still performs as required under the contract, whereas the other party, the original other party, is discharged, and now it is the assignee who owes duties under the contract. Substantial performance. This is a very important aspect. Substantial performance occurs when one party does not perform perfectly, does not render perfect performance, but their breach is not material. Substantial performance occurs when a party substantially fills a contractual obligation. Now, substantially is an adverb, and it is necessarily a gray area. What does substantially means? Well, we'll give you some ideas about how to determine whether that's true or not. But if a party substantially performs, the contract remains in force and the other party must perform, meaning that party who substantially performed committed a simple breach. They did not render perfect performance. Nevertheless, the other party, the non-breaching party, must stay in contract and must perform according to the terms of the contract. The law allows substantial performance to satisfy the requirements of the agreement and trigger the other party's obligation to perform. So say you hire a contractor to build a house, and the contractor clears the land for the house, lays the foundation, builds the house according to the specifications that you have attached to the agreement, finishes the interior to the agreement. Only 3 of the rooms in the house were painted the wrong color according to the terms of the agreement. That is substantial performance. They have performed most of what the contract called for. They still didn't perform perfectly, right? They painted 3 rooms the wrong color. Nevertheless, they are now entitled to demand from the non-breaching party their performance. Now, that performance can be limited by the amount that it's going to cost to finish painting the rooms, but in any event, the non-breaching party must still perform even though there was technically a breach on the part of the other party. How do you prevail in a substantial performance case? The party trying to enforce the contract must show that the deviation from the required performance was not material. Material, meaning important, meaning an element of the contract. Now, the party seeking to enforce the contract must also show that they acted in good faith. Now, material refers to deviation from the contract such that the performance altered a fundamental aspect of the agreement. So a material breach would mean that the non-breaching party has been deprived of what it was entitled to receive or what it expected to receive under the agreement. And in our situation of the house contractor, they got the house, it's just that 3 rooms were painted the wrong color. Now, the non-breaching party can recover its damages. In our example, that means they can recover how much it cost to paint the 3 rooms the proper color. The doctrine of substantial performance allows a party to meet their obligations in a contract even though their performance was less than perfect. Nevertheless, the non-breaching party can collect damages to compensate for the imperfect performance. The non-breaching party owes its full performance less any amount they have to spend in order to complete the performance. Courts allow the substantially performing party to be paid the full amount of the contract price, less any costs that were suffered. Now, there's another very famous case about substantial performance. It's a case called Jacob and Youngs versus Kent. In this case, Mr. Kent wanted to build a house and contracted with the contracting company of Jacob and Youngs. Now, the plans for the house called for the use of what was called Reading pipe. Reading was a manufacturer of wrought iron pipe. They advertised their product heavily as being of the greatest quality, and so when Kent went to build his house, he specified Reading pipe. Now, inadvertently, Jacob and Youngs used a different brand of pipe. They installed pipe that was not Reading pipe, but was substantially the same quality. Now, when the defendant, Mr. Kent, discovered this error, he demanded that the work be redone, which meant to essentially tear out most of the house, replace the pipe that was in there with Reading pipe. And again, Reading is just the manufacturer of the pipe. The manufacturer utilized in the house was of essentially the same exact quality. Now, when the plaintiff refused to correct the error, refused to tear out the house and rebuild it using Reading pipe, the defendant refused to pay the balance of what was owed on the contract. And so Jacob and Youngs, the plaintiff, sued Mr. Kent for the remaining balance. Now, in this case, the question was the defendant entitled to the cost of the replacement of the pipe for plaintiff's breach of contract? Now, there's no question that the plaintiff breached the contract because they did not use Reading pipe in construction of the house. However, the pipe they used was of the same quality. In fact, a representative of Reading pipe testified in favor of the contractor at trial to say Reading pipe was no different than the pipe used in the house, other than it was stamped with the manufacturer's name of Reading. What did the court do? Well, applying the doctrine of substantial performance, the court held that the appropriate measure of damage is the difference in value of the pipes, if any, not the cost of replacing the pipes. So under these circumstances, requiring perfect performance would be unfair. And so the contractor prevailed in that case because it had substantially performed the agreement. To the extent that there was a difference in value between a house with Reading pipe and a house that did not have Reading pipe, well, then the plaintiff, the defendant could avoid paying the difference between those values. We don't know what actually happened in this case, but I suspect the difference in value was minimal. Many have oftentimes questioned, why did Mr. Kent refuse to pay for the house? Surely it must not just have been about the use of Reading pipe, but we don't have an answer to that question. What we do know is that Mr. Kent was a person who was very cost conscious, that he believed that because Reading pipe was more expensive, it had to be a better quality of pipe, and he did not want to accept less than that quality in his house. All right, now, so we've talked about performance, we've talked about assignment, we've talked about substantial performance. How else can parties agree to mutually terminate their original contract? Well, the parties may terminate their agreement using any of the following methods. And we'll tell you what they are, then we'll go over to each one in more detail. The first is called rescission. Rescission is where the parties agree to return to their pre-contractual positions. Accord and satisfaction, a substitute agreement, and what's called a novation. Let's talk about each of those in more detail. Starting with rescission. Now, if neither party has fully performed, the parties may agree to simply cancel their contract. Each party gives up the rights under the contract in exchange for the release by the other party from performing their obligations. So essentially, the parties return to the position they would have been in had the contract never been executed. Rescission only occurs if both parties agree to rescind. And it is possible because of that doctrine of freedom of contract that we talked about when we began this entire module, in the sense that we should respect what people agree to in their contract, even if it is termination of the contract without performance. Now, a unilateral rescission, where one party says that they are not going to perform and in return will give up any right under the contract, that is not permitted. So it has to be a mutual decision in order to establish a rescission. Now, the second way in which parties can satisfy their obligations is called an accord and satisfaction. And in some cases, the parties to a contract agree to accept performance that is different from the originally promised performance. Under the doctrine of accord and satisfaction, one party agrees to substitute performance in the future, known as an accord, and the other party promises to accept substitute performance in discharge of the existing performance obligation. Now, this is a very convoluted way of saying that the parties can sometimes settle an agreement for a sum of money in less than that which would have been paid. So if you are someone who owes money on a debt and the debt is accruing interest at 20% a year, and it is certain that you are never going to be able to pay the debt plus the interest, well, the creditor, the person to whom the debtor owes the money, may permit the debtor to pay a lesser amount in order to get some money in, and then agree to discharge of the obligation. So if you owe $40,000, but you say, look, I will pay you $30,000 right now, cash, and the other party agrees, the creditor agrees, then that's an accord and satisfaction, which is to say we are going to agree to accept less than what we are owed. Now, once the substitute performance has been rendered, meaning you've paid the $30,000 that you agreed to pay in your settlement, then this acts as a satisfaction of the obligation, meaning you do not owe the amount that you originally owed because you have discharged your obligation through payment of a substitute amount. Now, discharge of the obligation occurs only when the terms of the accord are performed, meaning you must actually pay the $30,000. If the accord performance is not rendered, the other party has the power, the option to recover damages under the original contract or under the accord contract. So if you don't pay the $30,000, the creditor can sue you on the original contract, which was to say the $40,000 you owed, or they may choose to sue you under the accord contract, which is to say the $30,000 that you promised to pay. So now we've talked about rescission and we've talked about accord and satisfaction. Let's turn to another way in which the parties can discharge their obligations without performance. Contracting parties can discharge their obligations by replacing the original contract with a substitute agreement. Now, the substitute agreement is generally used to compromise when two parties have a dispute as to the performance of the contract and they wish to amend the terms. Essentially, this happens when the parties have entered into a contract and there was some disagreement as to what the contract actually called for. The parties can agree to a substituted contract for the original contract, again, because of the doctrine of freedom of contract. And once they have executed that substitute agreement, the substituted agreement immediately discharges any obligations under the original contract. The final way in which the parties can agree to discharge their obligations is called a novation. And in a novation, the parties agree to substitute a third party for one of the original parties to the contract. And when doing so, the agreement may be discharged through this novation. So it's kind of a substitute agreement that involves a substitute third party rather than a substitute promise. So in this case, I actually had a case where we had to execute a novation. My client was a contractor in Houston, Texas. He was contracted to work on a office complex in New Orleans, Louisiana. He got into a dispute with the corporation. He didn't believe that they were paying him enough. They disagreed about what was the scope of his agreement. And so he wanted to just simply walk away from the agreement. But the office complex was not willing to let him off of his obligations. He had signed a contract and they were going to hold him to that. And so what essentially we did was, myself, working with the counsel from the other side, agreed to a novation. We went out and found a contractor who would perform according to the terms of the original agreement, and we substituted our place in the agreement with the new contractor. So when the novation occurred, the novation revoked and discharged all of my client's obligations under the old contract. So it's a substitute agreement, except instead of changing an aspect of performance, we change the third party. We change one of the parties to the contract. The law itself can also discharge contract obligations. In some cases, unexpected events occur that would affect one party's ability to perform. And when that happens, the law may allow the parties to be excused from performance under the contract. Now, 3 doctrines permit discharge by operation of the law. The first is impossibility, the second, impracticability, and third, frustration of purpose. Let's talk about each of those in more detail. Impossibility. If it becomes impossible for one of the parties to perform, then that party could seek to be excused from its obligations under the contract. Now, impossibility must be an objective standard, meaning not simply that it is impossible according to the party who wishes to breach, but that it would be impossible to a reasonable person that the performance could not be achieved. It was impossible. So in other words, a reasonable person would also consider the obligation impossible to perform, rather than subjective, where one party unilaterally decides that performance is impossible for the obligation to be charged. Now, courts do not like to excuse parties from their performance, and so the modern trend of courts is against allowing impossibility as a defense unless it fits into one of four possible situations. The first is destruction of the subject matter. If you and I have agreed to I will sell you my house for $300,000, and you agree to purchase the house for $300,000. Well, if the house burns down prior to performance under the contract, it is impossible for me to perform. So destruction of the subject matter will discharge a party's obligation. Death or incapacitation of one of the parties to the contract. If one of the parties dies, the estate does not have to fulfill the contract. The means of performance contemplated in the contract cannot be performed. This would occur if, in fact, the parties had called for performance in a certain manner, and that simply could not be performed. And then finally, illegality. If performance of the obligation becomes illegal after the contract, but before performance, so after the contract is executed, but before performance is required, then the court will discharge the parties from the contract. Now, the second way we talked about is impracticability. And impracticability is a legal term. And essentially it means not impossible, but so difficult as to make the point of the contract meaningless. So to prevail on a claim of impracticability, a party must generally show that an unforeseen event occurred, something happened, the event made performance impracticable, the non-occurrence of the event was not foreseeable when the contract was made, meaning they could not foresee this type of event occurring, the event was not the party's fault, and the parties were acting under the assumption that the event would not occur. The third means of terminating a contract by operation of law is what's known as frustration of purpose, and it is again closely related to impossibility and impracticability. In this case, the courts may discharge a party's performance under a contract if an event occurs that destroys the party's purpose in entering into the contract. So frustration of purpose may be used if after the parties enter into an agreement, a party's principal purpose is substantially frustrated without their fault, and some event occurs when the non-occurrence of the event was a central assumption of both parties when entering into the contract, and the parties have not otherwise agreed on who bears the risk of such an occurrence. So if a company, for instance, contracts for new clothing, maybe it's a retail clothing company, and they contract with a manufacturer for the purchase of new clothing, and then the company, for whatever reason, the original contracting company goes out of business. Well, then there's no point in going through with the contract, and so this is when we would cite frustration of purpose, that we cannot go through the contract because the point of the contract, which was to sell the clothes in the store, is no longer possible because the store has closed. Now, the burdened party must show that the event was unforeseeable and extreme. Maybe there was a pandemic that struck and cause the store to go out of business. We saw a lot of places close during the COVID pandemic, and so maybe that would probably serve as a great example of frustration of purpose. The last thing we want to talk about is the force majeure clause. Now, these situations we've talked about so far, things like impossibility, impracticability, frustration of purpose, those are going to be difficult to establish. And as with all things, courts are reluctant to let people out of contracts, and so it can be difficult to succeed on any of those three defenses. So what lawyers have done is to create a clause that goes into a contract that essentially permits termination of the obligations under the contract through contractual means. So sometimes parties add a clause that contemplates uncontrollable acts that will impede performance under the contract. Lawyers will frequently advise their clients to incorporate what's called a force majeure clause into their contract. Force majeure is a French word meaning superior force. And this clause is a contract clause that excuses a party from failing to perform on the occurrence of one or more specified events, such as war or blockade or fire or riots or pandemics, threats of terrorism, strikes. We include all of these in the contract. And the reason we do that is by citing force majeure, the party that does not perform is complying with the contractual terms and thus does not breach the agreement. They have not breached the agreement. They are performing according to the contract, which has a clause that says if when one of these things happens, we don't have an obligation to perform. So this is what we call a contractual remedy. The other defenses we asserted, things like impossibility and impracticability and frustration, those are what we call extra contractual remedies. They come from outside of the contract, but the force majeure clause allows the parties to stay in compliance with the contract, but yet discharge their obligations. I put a sample force majeure clause onto Canvas. Go check it out and you can see how these things work in real life. So in conclusion, what did we learn today? The parties must be able to identify when the contract's obligation and rights have terminated. The termination of a party's obligations under a contract is called discharge, and discharge occurs in different ways, through performance, through mutual agreement, or through operation of the law. Thanks a lot. I know this was a tough one to get through. If you have any questions, let me know. Otherwise, we will see you in the next one.